Welcome to Forensic Perspectives, the legal community's online resource for the latest in forensic accounting, business valuation, and financial litigation support. Your host for this podcast is Mark Gottlieb. In addition to being a certified public accountant, Mark has also obtained many professional accreditations in forensic accounting and business valuation. As one of the Tri-State's leading financial experts, Mark is also a frequent lecturer and writer. Without any further ado, please welcome the host of Forensic Perspectives, Mark Gottlieb.
Thank you, and welcome to today's program. The summer of 2010 may be remembered by many family law practitioners as the historic summer of legislation that will forever change how matrimonial law is practiced in New York State. There have been 5 major changes that have been effective in October 2010. These changes include the following. 1. Significant changes effectuating child support modification. 2. NoFault Divorce. 3. The new Counsel Fee Bill that addresses payment of attorney's fees. 4. The procedures for setting awards of temporary maintenance while a divorce is pending. And 5. Limiting the grounds by which orders of protection may be denied or applications for such orders may be dismissed. Many of these changes include significant financial implications, and according to New York State Governor David Paterson, this will bring New York's divorce law into the 21st century. Governor Paterson has also been quoted as saying that these bills fix a broken process that produced an extensive and contentious litigation, poisoned feelings between the parties, and harm the interests of those persons, too often women, who do not have significant financial wherewithal to protect their legal rights. To discuss these major changes, we welcome attorney Henry Berman. Mr. Berman is the managing partner of Berman, Bavaro, Fruco & Gauss, located in White Plains, New York. Since its inception, his firm has practiced exclusively in the area of matrimonial law. Mr. Berman's professional distinctions include, but are not limited to, being listed in Best Lawyers of America matrimonial law in every year since 1989, selected as one of the 10 leaders in matrimonial law in the 9th Judicial District in every year since the list was created. He has also been one of the top 25 attorneys in Westchester, chosen by the New York Times Super Lawyers section. Since 1980, Mr. Berman has been a fellow of the American Academy of Matrimonial Lawyers. He has served as vice president and executive committee member of the American Academy of Matrimonial Lawyers in the New York State chapter. Henry, thank you for joining us today.
It's my pleasure to be here.
First, before we discuss the 5 individual bills, what's your take on the governor's statement, and do you think the divorce process is actually broken?
Well, first, let's go back to his first statement, which was it brought us into the 21st century. Actually, these bills probably brought us into the 20th century. We've been behind the rest of this country, certainly on grounds for divorce, for many years. With respect to fixing a broken process, I think you'll find that adopting no-fault divorce, true no-fault divorce, which is our new ground of irretrievable breakdown of the marriage, that certainly does fix a broken process. With respect to the child support modification, I don't think the process was as broken as he may think, but it's certainly a change in the law which may be beneficial. I think the Counsel Fee Bill is a significant advantage for less money spouses and will be the fixing of a broken process. With respect to the temporary maintenance bill, we'll talk about that later on. I think they got it all wrong on that one, but let's hold for a while on that.
Okay, before the no-fault divorce legislation was passed, couples at both ends of the economic spectrum often had to leap over hurdles in addressing grounds. But now that grounds are no longer an obstacle if certain financial and custody issues have already been resolved, no-fault provisions are only applicable after a marriage has been irrevocably broken down for a 6-month period or more. What is your view on some of the new issues that no-fault legislation presents to attorneys and those who are considering getting divorced?
Well, the first question is, what did the legislature mean by irretrievable breakdown of the marriage for more than 6 months? We presume that they meant you simply make that statement because that's what the statute says, and a court will grant a divorce. However, that remains to be seen. I suspect that there will be people who are defending and saying when the plaintiff says the marriage is irretrievably broken down for a period of more than 6 months, there'll be a denial of that statement, and a question will be raised, do we have to try that issue? If we have to try that issue, what is the standard of proof that a court will require? We simply do not know. I know that our legislature worked under the assumption that we were getting, if we give the expression, divorce on demand, at least on the issue of grounds for divorce. But that remains to be seen what the courts will do.
Do you think that this issue is going to be litigated?
It may very well be litigated. Let's make sure we understand what our statute has always done. The statute lays out grounds for divorce. If you want a divorce, you plead that ground. If it were cruel and inhuman treatment, you had to plead that my spouse was cruel to me and delineate each and every one of the acts of cruelty on which you relied. If you were suing for abandonment, the person left you for more than a year, you so had to make that allegation. Well, when somebody prepares and serves a pleading, the defendant gets the right to respond to that pleading. It's called an answer, as the lawyers in the audience will tell you. That answer can deny the allegation. If the allegation is denied, then theoretically at least it has to be proved by testimony. We simply do not know what will happen. But if you're asking me if somebody will enter a denial and try to litigate the issue, absolutely.
So the statute just uses the term broken down for 6 months or more. It doesn't really define what has broken down.
No, it does not.
So we don't know if these people are living together or they're living apart, if they're having relations, if they're supporting each other. None of these factors have been considered in the legislation.
No, that's not the standard they say. They say the marriage has broken down irretrievably for a period of at least 6 months, provided that one party has so stated under oath. Now, we may be looking to other jurisdictions who've had this ground to see what standards they applied, but nobody's yet done that. From a realistic point of view, I think the courts are going to say, don't play this game with me. We're a no-fault state. You want to get divorced, just tell us you want to get divorced, and we'll get on to the financial issues, which is why they made such a big deal about no divorce judgment can be entered until all the financial and support, child custody and support issues have been resolved. But there are also going to be judges who don't like this bill and may very well write a decision which says irretrievable breakdown means more than I don't like you anymore.
Does this bill, the way you read it and the way it's perceived by the legal community, does it favor or address a certain couple that's in a particular economic stage in their life? Is it really more suited for couples with significant means or modest means that have anything to do with that? Because the financial issues have to be resolved before the no fault can be addressed.
Well, no, the financial issues have to be resolved before they can enter the judgment. I don't think the bill makes a difference whether you're, forgive the expression, rich or poor. I think the intention here was to take away the leverage that people would use and the cost of litigating cases, the expense, both emotionally and financially, and the strain on the courthouse and all of the other resources which got used up fighting about whether or not people who were not getting along, or at least one of them wanted out of the marriage, whether he or she could get out.
Does the legislation and the bill address only divorces that were commenced subsequent to the October date? What about the divorces prior?
No. The law on its face, and each of the laws we're going to talk about today, are effective only for things after October 12th or 13th. One of them only applies after October 13th. But no-fault divorce is only for an action for divorce brought after October 13th, or 12th, I'm sorry. If there's an existing action, that's governed by the old law.
Just as an aside, do you think that some people will terminate their action now, and then maybe a couple of months or a couple of weeks from the October date commence a new action?
It's a very good question, and the answer is a little esoteric. It really depends. Remember, if you discontinue an action for divorce, then you lose the effective cutoff date for the purposes of when marital property is being acquired. Remember, marital property is all property acquired during the marriage up to the date of the commencement of an action for divorce. But that presumes that it'll be a divorce. If you discontinue that action, there'll be a significant argument that you, in effect, opened the pot. And so that additional assets which are acquired, let's say between your August commencement date, which was no good, and December, could be marital.
It's interesting how when those of us that work either from the legal or the accounting end of matrimonial law, there's been a tremendous discrepancy between opinions from professionals stating whether this particular no-fault issue is or isn't significant. What's your overall reaction?
Okay, I think it's an incredibly significant bill for the following reasons. There are people who want out of their marriage who do not have traditional grounds and do not have the ability to do what other people have, which is to move to the state of Connecticut, to move to the state of New Jersey, to move to the state of Pennsylvania, to move to the province of Ontario. I'm describing states which surround New York, to move to Vermont also, all of which are no-fault states. Because if I live in Westchester County and I want a divorce, and my wife has done nothing wrong, and therefore under traditional New York law, I didn't have grounds, I could always move to Connecticut. It's 10 minutes from here. And get my divorce in Connecticut after I satisfied their jurisdictional requirements. And there was nothing she could do about it. But she didn't have that leverage or that ability if we had young children at home and she didn't want to give them up. So she was bound to stay. And if she didn't have grounds for divorce, she had real problems in proceeding. Now I take you to the middle of this state, the parts of the state which are hundreds of miles from the border of another state, and those people were disadvantaged because neither of them could move to a no-fault state. So I think it has significance at that level. I also think it has significance at the level that divorces should be less expensive and that people can't hold other people up for more money so that you'll give me my divorce. And we will not be creating all the animus that we create when we seek a divorce today. Remember, under traditional fault grounds, I had to prove that you committed adultery. I had to prove that you were guilty of cruelty of such a nature to make it unsafe or improper for you and I to reside together, or you abandoned me for more than a year, all of which were pretty tough allegations when you were on the receiving end of it, and it didn't make you very happy. And therefore, we got to like each other even less than we did in the first place, and that wasn't good for our families, and it wasn't good for the fact that we have to deal with our children for a long time together. And so all of this is very helpful in the process of society.